Hello everybody, and welcome to part 4 of the Maryland Listing Agreement and Listing Disclosures Training Seminar. I'm so excited to have you with me, and today we're going to cover the Montgomery County Listing Disclosures. The reason that Montgomery County requires its own training session is because its listing disclosures are a bit more lengthy than the rest of the state. So I hope you're excited to get started. I know that I am. So as part of the Montgomery County listing disclosures, there are 3 things that are going to be included specifically for Montgomery County. One, that's the Montgomery County Jurisdictional Addendum. Then there's the Regulations, Easements, and Assessments disclosure. And finally, the Utility Cost and Usage History. We're going to go through each of these in some detail. Now, the thing we're going to learn about Montgomery County is they want to make sure that we do everything 2 and 3 times to make sure that the seller and buyer understand exactly what's going on. They're making an assumption that your buyer or seller has an IQ of 75. So that's why we're going to cover agency again, even though it's covered in the Maryland contract. Fair housing, same thing. Transfer and recordation fees. Maryland non-resident transfer withholding tax. And finally, receipt of information and compliance of disclosures, which means they want to make sure that you receive all your other disclosures that are in the packet. Now, starting with paragraph 1, agency. Agency disclosure and consent for dual agency. Seller acknowledges broker has informed seller of his rights and obligations as defined in forms, understanding whom real estate agents represent, and consent for dual agency, copies attached hereto. Ministerial acts. Seller agrees listing agent may perform ministerial acts for buyer. A ministerial act is an act that does not involve discretion or the exercise of the agent's own judgment. And what's funny is this is the Montgomery County Jurisdictional Addendum to the Listing Agreement, but that very thing is in the Maryland Listing Agreement already. So they just want to make sure they saw it twice. Fair housing. Now, fair housing for Montgomery County is actually, there are a few more protected classes involved, so that would make it necessary to be in here. Seller acknowledges Montgomery County and the state of Maryland require the subject property shall be made available to all persons without regard to race, color, religious creed, ancestry, national origin, sex, marital status, disability, presence of children, family responsibilities, sexual orientation, source of income, age, or gender identity. Okay, now part 3, transfer and recordation fees. Montgomery County has its own transfer tax, where usually we have a county recordation tax and then the Maryland transfer tax. Montgomery County actually has its own county transfer tax also. The bottom line is it talks about first-time home buyers here, how the first-time home buyer has their state transfer tax waived. This just says that the seller will pay that unless it's negotiated otherwise in the contract. And also Part C here, that if they are a first-time home buyer, the state actually reduces the state transfer tax in half, therefore effectively waiving it for the buyer. Seller still pays their portion. And Part 4, Maryland non-resident seller transfer withholding tax disclosure. This is directly in the residential contract of sale also. So it's a little bit redundant, but it's just saying that if they're a non-resident in the state of Maryland or a non-state entity and the property they're selling has not been their property for 2 of the last 5 years and they live out of state. So they could have moved out of state to Florida last year, but this property was their primary residence for 2 out of the last 5 years, then they're still exempt from this. But if not and they're out of state, then they have to, the state will withhold 7.5% of the total payment to a non-resident individual or 8.25% to a non-resident entity. What that means is they must file a tax return at the end of the year to get that withholding back if they're entitled to it. And then finally, Part 5, receipt of information and completion of disclosures. Seller acknowledges receipt of and or completion of the following disclosures and authorizes broker to make them available to prospective purchasers. Now, these are all the addenda that are going to go in the contract, and they're just saying that the seller acknowledges receipt of them with the rest of the listing agreement. And we covered all of these in parts 1, 2, and 3 of the listing disclosures training previous to this one. So again, in Part 4, they're just saying, hey, did you get all the other ones we just covered? So the Maryland Residential Property Disclosure and Disclaimer Statement, Information and Disclosure of Lead-Based Paint, Maryland Lead-Based Paint, Government Regulations, Easements, and Assessments Disclosure, which is coming up next, Inclusions and Exclusions Disclosure, and the NAR pamphlet, What Everyone Should Know About Equal Opportunity in Housing. Finally, paragraph 6, Termination. This just sets, even though the original listing agreement has a paragraph for termination, they thought they'd just throw a second one in there for good measures. This agreement may be terminated prior to the end of the listing period by either party delivering however many days notice to the other. In the event seller terminates this agreement pursuant to this paragraph, seller shall compensate the broker, and then you put in there whatever your compensation is. Offer presentation. All offers or counteroffers shall be presented to the client in full as a hard copy or an electronic format unless otherwise specified here. So that means if you receive an offer, you can't just call them verbally and tell them. You've also got to forward that offer in whatever its form is via email or hard copy. And then everyone signs and dates at the bottom. Okay, moving along to the Montgomery County Regulations, Easements, and Assessments Disclosure and Addendum. Now, this particular disclosure is 9 pages long. Montgomery County, for whatever reason, has a reputation for a lot of litigation. So the purpose of this disclosure is to hopefully keep your sellers and buyers out of any hot water with each other and with the county. So starting with the notice to seller and buyer, this disclosure addendum to be completed by the seller shall be available to prospective buyers prior to making a purchase offer and will become a part of the sales contract for the sale of the property. What this means is your seller is going to fill out this document and all of the information that goes along with it that they have knowledge of, and you're going to upload this with the rest of your disclosures so that a buyer and their agent has immediate access to it prior to making the offer. And it lists in there further government agencies and entities that they can call for further information to complete their due diligence process. Paragraph 1, Disclosure, Disclaimer, Statement. So again, like I said, Montgomery County likes to do everything at least twice because they're assuming your IQ is maybe an 80 or below. A property owner may be exempt from the Maryland Residential Property Disclosure Act as defined in the Maryland Residential Property Disclosure and Disclaimer Statement. Is the seller exempt from the Maryland Residential Property Disclosure Act? Yes or no, check a box, and if no, see attached Maryland Residential Disclosure and Disclaimer Statement. If yes, reason for exemption. So the reason for the exemption might be that it was a property that was inherited, it was a bank that foreclosed on the property, etc. So just like in the disclosure disclaimer statement and disclosure that lists all of the exemptions, this is just them asking the question one more time. Paragraph 2, smoke detectors. So this is just listing out here what the regulation is for smoke detectors and the replacement of any battery-only smoke detectors, so that if the battery runs down, they want them to be hardwired into the property so that they'll always be working, as of 2018 anyway. So that's paragraph 2. Paragraph 3, in Montgomery County they have moderately priced dwelling units. So they're asking here, is this the property part of the moderately priced dwelling unit program in Montgomery County or the city of Rockville? Yes or no, check the box. If yes, the seller shall indicate the month and year of the offering. If initial offering is after March 20th, 1989, the prospective buyer and seller should contact the appropriate jurisdictional agency to ascertain the legal buying and selling restrictions on the property. And what that means is, in Montgomery County, every development or planned urban developments, PUDs, were required to have moderately priced dwellings somewhere in that development. And they were drastically reduced in price, but there were also restrictions on when they could be sold. And so that's why they're asking for you to check that out to make sure there are no further restrictions on title, because there are restrictions for a certain time period. Okay, moving along to page 2. Page 2 is primarily going to involve radon and the availability of water and sewer. So paragraph 4, Radon Disclosure, we're going to go through this one because it's new this year, so it's important that we go through it in its entirety. Effective October 1st, 2016, a radon test must be performed before completing the sale of a single-family home in accordance with Montgomery County Code Section 40-13C. A single-family home means a single-family detached or attached residential building. Single-family home does not include a residential unit that is part of a condominium regime or a cooperative housing corporation. The seller of a single-family home, unless otherwise exempt below, is required to provide the buyer a copy of radon test results performed less than 1 year before settlement date, or permit the buyer to perform a radon test. Now, this is new. Radon always before was kind of an optional thing, just like a home inspection, where here Montgomery County is saying this year and beyond it's now required, and they're actually asking the seller to do it. However, it says that a buyer is able to perform the test also. So moving along, is the seller exempt from the radon test disclosure? Yes or no? If yes, the reason they're exempt. And now we're going to list the exemptions. A, the property is not a single-family home, which means single-family or a townhouse, but not a condo. B, transfer is an intra-family transfer under Maryland Tax Property Code Section 13-207. C, sale is by a lender or an affiliate or subsidiary of a lender that acquired the home by foreclosure or deed in lieu of foreclosure. D, sale is a sheriff's sale, tax sale, or sale by foreclosure, partition, or by the court-appointed trustee. E, a transfer by a fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. Or F, a transfer of a home to be converted by the buyer into a use other than residential or to be demolished. What's funny is these exemptions are the very same exemptions for the disclosure disclaimer statement. Now, you don't have to memorize all of that. Just know that if they are exempt from one, they're exempt from the other in Montgomery County. If not exempt above, a copy of the radon test result is attached, yes or no. If buyer elects not to perform a radon test under Montgomery County Code Section 40-13C, the seller is mandated to perform the test and provide the results to the buyer prior to settlement. So what is that saying? The buyer is electing not to perform it. That means the seller must perform it. Very interesting, and that's why we want to cover this. So buyer or seller will perform a radon test in accordance with Montgomery County Code Section 40-13C. So that means radon itself is now something to be negotiated if you represent the seller. If you're the buyer and it's never negotiated, well, that means, I guess, that the seller is going to pay for it. Note, in order to request seller to remediate, a radon contingency must be included as part of the contract. Okay, so that's very interesting for paragraph 4 with radon, and that is new. And moving along to paragraph 5, the availability of water and sewer service. Now, this is more just disclosing, okay, is water and sewer available? Here's where you get the here's where you can verify all of that information. Well and septic locations, here are the websites to use to see where all of that is located and the permitting for it and the drawings, etc. And then finally, just some questions below so that all of that information can be disclosed to the potential buyer. Water. Is a property connected to public water, yes or no? If no, has it been approved? And if not connected, the water source is potable water, if any, for the property is blah, blah, blah. Sewer. Is a property connected to public sewer system, yes or no? If no, the following questions. Has it been approved for connection? Has an available sewage disposal system been constructed on the property, yes or no? Has one been approved? Has one been disapproved? And that might be important for them to know. And then the categories, the water and sewer service area category, or categories that currently apply to the property are, and then if known, whatever that might be. This category affects the availability of water and sewer service as follows, and then you would put in whatever that information that the seller gives you. And the reason that they want to disclose that is because that can potentially affect the value of that property and would be considered a material fact in the buyer's decision to buy or not. And that's what, when we talk about material facts, we're talking about one that would actually influence their decision one way or another in their decision to buy that property. And continuing on with our availability of water and sewer, D, recommendations and pending amendments. The applicable master plan for the county contains the following recommendations regarding water and sewer service to the property, and whatever that might be. And then 2, the status of any pending water and sewer comprehensive plan amendments or service area category changes that would apply to the property. Now this is important so that a potential buyer knows ahead of time if they're buying a property that's going to have some sort of substantial changes or master plan changes that could possibly include with them special assessments. And a special assessment means that any new infrastructure that the county puts in that might affect that property, they're going to give a special tax assessment to that area for a period of 10 years, maybe even 20 years. So it's important that the buyer know that ahead of time, so they're not blindsided by any additional charges a year or two from now that they knew were coming, or should have known, the sellers at least should have known. Okay, well, an individual sewage system. Individual sewage system means like a septic system or something like that. And what Part E is really saying is that the plat map or the from the Department of Health, whenever that property is originally perked for a well and sewage system, usually they'll put on there what the best areas are to have the septic drain fields, etc. So if there was only one area that was available and that was it, let's say the septic system goes out and they have to dig a new septic system somewhere else, then they would have a huge expense if the property just wasn't suitable for a separate area to have a drain field, etc. I know that's a long-winded way to explain it, but that's why they need to be able to sign off on the plat. The buyer is supposed to sign off on it, say that they've seen it, and that they know that what areas are available as far as a new septic system goes, etc. That's why they have to sign off and initial the plat and sign here. So they can't say, oh, the septic went out 3 years from now and now it's going to cost $30,000 because the property wasn't suitable for a separate drain field. Moving along to paragraph 6, City of Tacoma Park. Oh, I love Tacoma Park. Tacoma Park is actually a nuclear-free zone, believe it or not. So obviously you can imagine if they're a nuclear-free zone, they've got a whole other several pages of disclosures just for Tacoma Park, but we're not going to include that here. But it is in Montgomery County, so they're acknowledging here that if you're in the city of Tacoma Park, there's a whole separate tree notice of tree preservation and park sales disclosure, etc. Paragraph 7, homeowners condominium or cooperative association assessments. So they're going to mark there if it's an HOA, condo association, a co-op, or whatever the situation is. Paragraph 8, underground storage tanks. So they're going to disclose here if the property contains any underground storage tanks. And paragraph 9, deferred water and sewer assessment. This goes along with what we were talking about before, where there's something that's called a front foot fee you may have heard of, and it's basically going to be like the special assessment. So when putting in any infrastructure in the area, or let's say it's been approved for something but it hasn't quite hit the tax bill yet, the seller has to disclose it here so the buyer isn't blindsided by any additional special assessment taxes in the future for infrastructure that's being put in. And private utility company, same thing. They need to know if there are any charges paid to a private utility company which do not appear on the attached property tax bills. So, also effective October 1st, 2016, notice required by Maryland law regarding deferred water and sewer charges. And if there is any, if they're subject to a fee or assessment to cover or defray the cost of installing or maintaining during construction all or part of the public water or wastewater facilities constructed by the developer, and then whatever that fee is. All of this is designed so that the buyer is not hit with any unexpected or hidden fees that are going to come up on that property regarding the infrastructure. As we start at the top of page 4, that's a continuation from the bottom of page 3 about private utility companies. And the top portion here, what this is saying is that the lien holder is actually the one that has the fee against the original buyer and the assessment. It's between the lien holder and that original owner, and the seller has to disclose this to the new buyer prior to the sale of the property, and then they can terminate that property within 5 days. The buyer can, that is. However, if this is never disclosed and following the settlement, the seller shall be liable to the buyer for the full amount of any open lien or assessment from that lien holder. Paragraph 10, special protection areas. Now, it gives a link here to refer to for this is mostly environmental. Is this property located in an area designed as a special protection area? Yes or no? And if yes, this is letting them know special water quality measures and certain restrictions on land uses and impervious surfaces may apply. Under Montgomery County law, special protection areas means a geographical area where A. Existing water resources or other environmental features directly relating to those water resources are of high quality or are unusually sensitive. B. Proposed land uses would threaten the quality of preservation of those resources or features in the absence of special water quality protection measures which are solely coordinated with appropriate land use controls. An SPA may be designated in 1. A land use plan, 2. The Comprehensive Water Supply and Sewer System Plan, 3. A watershed plan, or 4. A resolution adopted after at least 15 days' notice and a public hearing. The buyer acknowledges by signing this disclosure that the seller has disclosed to the buyer the information contained in sections A and B before buyer executed a contract for the above referenced property. Further information may be available from the staff and website of the Maryland National Capital Area Park and Planning Commission. Now, it's important that the buyer knows this because a lot of these environmental regulations can limit the use of the property. And then finally, paragraph 11, property taxes. So this paragraph explains that Montgomery County has several different categories and components that are applicable to the property for the calculation of property taxes. And it simply lists what some of them may be, gives a website for the buyer to look that information up so they can make the decision themselves as to what type of category this property falls into. And continuing on with property taxes, paragraph A, current tax bill. So in Montgomery County, we have to provide a copy of the current tax bill, not just the tax record, but the tax bill itself. But at least they provide a link right there so you can pull a copy of the tax bill. But furthermore, paragraph B, this says that we're also providing a tax estimate for the first fiscal year that the buyer will own that property. And again, there's a link right there for you to be able to pull that up. And then those have to be provided along with this disclosure, and the buyers have to initial this. So Montgomery County, we go a step further, and they're going to have to actually pull the tax bill and do an estimate of the next fiscal year's tax bill as well. Paragraph 12, Development District Disclosure, Notice of Special Tax or Assessment. Now, notice in this Montgomery County disclosure, we've been talking a lot about special taxes, front foot fee, special assessments, and this is just another possible special taxing district or special assessment. So the seller's going to have to mark whether the property is located in an existing development district, which just means that there's an additional special assessment for, say, infrastructure that's being put in or has been put in. Or they check if the property is located in a proposed development district, meaning it isn't yet, but it could be. Or finally, check if the property is not located in an existing or proposed development district. That's important for obvious reasons of the buyer has to know if there's going to be a special assessment coming in the future. Paragraph 13, tax benefit programs. Now finally, they get to mention whether the property is part of something that's going to give them a tax break, such as a forest conservation and management program, agricultural program, other tax benefit programs. Paragraph 14, recorded subdivision plat. Now, Montgomery County makes it easy to pull up the plat maps, which is very nice actually. They provide a link right here where you can pull up the maps. Now, for unimproved lots and new construction, it must be provided. If it's a residential resale, then it can be provided or waived, and they just are going to check which box it is. Whether, again, new construction, they have to provide it. Residential resale, they're going to check box B or C, depending on if they're going to waive it or not, and then initial. 15, agricultural reserve disclosure notice. They're going to check if the property is or is not subject to the agricultural reserve notice or disclosure requirements. Paragraph 16, notice concerning conservation easements. Again, is this property a conservation easement or not? And that will actually be, that's the second time we're going to see this, because in the actual listing agreement it asks these same questions. Ground rent. The property is or is not subject to ground rent. We're not seeing that a whole lot anymore, especially even in Baltimore. They're actually selling those off. 18, historic preservation. Now, this is important, and if there's any question about this whatsoever, please look it up. The property, it's got to be disclosed if it's historic preservation, because there are so many restrictions put onto the land use in if it's got a historic designation. And at the top of the page, we're going to continue on with the historic district rules and regulations and guidelines. The city of Rockville, this gives some guidelines there of what the seller or buyer should do, or what may cause them to look into whether it's historic or not. Same thing with Gaithersburg. Then they're going to check a few boxes of if it's in the master plan as historic preservation, historic district, and on the county location atlas of historic sites. And they're going to disclose that, check those boxes to the buyer, and then the buyer is going to sign that they acknowledge that. Paragraph 19, Maryland forest conservation laws. So this here is interesting. If they're going to cut down, clear, or grade more than 5,000 square feet of forest or any champion tree on the property, it's subject to the requirements of the forest conservation law, and then they're required to comply with that in the Montgomery County Code. Forest conservation easements, the seller is going to warrant that the property either is or is not currently subject to a recorded Category 1 or Category 2 forest conservation easement management agreement or an approved forest conservation plan, etc. And if it is, they'll know it. Make sure they disclose it. Paragraph 20, airports and heliports. So this is just a notice from the county that there may be heliports, airports, and other noise-producing facilities such as that. And they even go as far as providing a map with the locations of various facilities that are going to be either using heliports or any aircraft. You can see here even they list every single facility so that if there's any question about how close it is to this property, they can look it up. And finally, paragraph 21, energy efficient disclosure notice. So all of these little disclosure notices about energy efficiency are to be provided, or at least the links here. And then usage history. Is the property owner occupied for the immediate 12 months prior? Yes or no? And that's going to be important because the next thing we're going to provide is what the actual utility costs and usage history was for the last 12 months. And then you're going to have your sellers sign and date that, and then the buyers will sign and date it once it becomes part of the contract. And then finally, we have the utility cost and usage history form. You're going to have your sellers fill in the month, the year, the electric, gas, and oil if they have it, a breakdown of that, and then the total cost. And I believe that the point of all of that stuff, and if we notice a common theme in the Montgomery County regulations and disclosures, are really representing a total and true cost of ownership is what they're really getting at. So just make sure that your people fill in the utility cost and usage history form as accurately as possible. And that's it. So just to recap, we covered the Montgomery County Jurisdictional Addendum, which covered a lot of the things in the original listing agreement, the regulations and easements and assessments disclosure, that was the big one, and finally the utility cost and usage history form. Now that sums up what you're going to have to do in addition to your normal listing agreement, disclosures, and addenda. If you're doing a Montgomery County property, it's going to have to include those 3 additional items on the listing side. Now that's going to conclude our training on the Maryland listing disclosures, and I want to thank everyone for sitting through that, and make sure that you check out the buyer agreement training, the core contract training, and the buyer systems training that we also have available. Again, this is Tim Brooks with the Brooks Group and the Ultimate Selling Team at Keller Williams Realty. I want to thank you for joining us on this training, and I look forward to our next session.